Start. The court took up the case and asked the counsel to state the facts of the plea filed by the party who had come before the bench in search of fair relief and clear orders that would help him get his rights as set out in the law of land and in the rules that guide all such claims in our system of justice, where each side gets due chance to speak and to place the case in full detail before the learned judge, who has to weigh all facts with care and give a sound order that stands firm in law and in logic, and that can be upheld by higher courts if the same is put to test by way of appeal filed by the party that feels hurt by the ruling that may go against him in the whole or in part, and that may also raise points of law that call for deeper look and wide view in light of past cases and clear text of the statute that rules the field in which this case lies, and in which the bench must act with due care and due calm. The counsel for the plea said that the act done by the state unit was not in line with the code and was in fact a breach of fair play, as the move to stop the grant was made with no base and no proof, and was done in haste and with no note sent to his client, who had to face loss due to the sudden step that had no cause and no ground that can stand in court when put to test by facts that form the core of the plea. The court asked the state side to show why such a step was made when the file did not show any act by the claimants that could harm the fund or the goal of the scheme in which the grant had been made, with due check and due rules that bind all such funds. The state side said that an audit team had made a point that some parts of the file were not clear, and that the fund was put on hold till the check was done, but the plea said that no such check was in fact done, and that the hold was kept for long, which hurt the right of the party who had used the grant in good faith and for the right end for which it had been given by the board. The court said that a grant, once made with due care, cannot be put on hold with no base, as such a move has wide effect on the work for which the grant was meant, and the court also said that the plea makes out a case that must be heard in full so that truth can come to light and the right side can get the due relief that the law grants to all. The judge then asked both sides to file short notes on the points of law that rise in this case and that need to be seen in the light of past law as led by the top court, where it was held that all steps of the state must be just, fair, and in good faith, and that No act of the state can harm a party in a way that is not backed by sound cause and a sound base in fact and in law. The plea then said that the grant was key for the plan that his group had made to run a small scale unit for poor youth in the block, and the hold on the fund had led to halt of the work, and the youth had to go back home with no clear date for next class, as the unit did not have cash to pay the team or to buy raw goods that were key to the skill class. The court said that if this is true, then the state must act with speed, as the right to run a fair plan for the good of the people is part of broad right to live with fair means and fair chance, and if the state harms such a plan with no base, then it is for the court to step in and fix the harm with a sound order that gives the group a way to start the work once more. The state side said that he will get the full file in 2 days and will place all facts for the court to see that the audit note was not the end but was in fact a step that had to be seen with more check, and once that check is done the fund can be freed if the court so holds. The judge said that the court will not let the case drag, as the plan is for youth and must not stop for long, and the bench then told both sides to come back with all facts so that the court can see the truth with clear view and can pass a fair and just order. The plea then told the court that his group has been in the field for 10 years and has done all work with full care and has kept all bills and all files in neat form and is glad to show them to the state, but was said that no one came to check the same, and the fund was kept on hold as if the group had done some wrong act when in fact no wrong was done at any stage, as all steps were in line with the rules made by the board. The court said if the file is neat and the bills are in place, then the state must have no fear to free the fund and let the plan run. The judge also said that the state must note that all such units that work for poor youth must get due help from the board, as this is key for growth and for a good life, and no group that works for the good of people must face such hold with no cause as that breaks the trust that the law seeks to build with the state and with the board. The plea then said that due to the hold, the group had to take loan to pay rent of the shed and to pay the team, as they did not want to leave, but now that cash is due and the group is in fear that if the fund is not freed then they will face more loss. The judge said that the court will take note of all this and will also see if the state must pay some form of cost to the group for the harm done if the court finds that the hold was done with no cause and no ground, and that the state must take care of the trust that the law and the people place in them. The court then Next, the court then set the next date and told both the sides to be ready with all facts so that a fair and just order can be made in line with law and truth, which is the first aim of all courts in this land. The court then said that all sides must see that the aim of law is not to harm any group but to guide all acts in a fair path and to make sure that no one uses power in a way that hurts the weak or the small units that try to serve the public with pure aim and clear mind, and if any such harm is done, then the court must step in with due speed so that faith in law stays strong for all those who seek justice in hard times. The plea firm said that they trust the court and will place all files on the next date and hope that the bench will grant relief that can help them start the plan once more with hope and clean start. The judge said that the court will see all facts and will pass an order that keeps balance of law and need of the people. Full stop.